Today, I would like to discuss how title passes upon the death of an owner who dies without a will. All real property owned by the deceased who leaves a surviving spouse is considered and presumed community property, unless the real property was acquired before marriage, inherited, received by gift, or is personal injury compensation, or lastly, divided by written agreement between the spouses. If the deceased received the property in any of those ways, then the property is separate property, and when the owner dies without a will, the property immediately vests as follows. 1/3 of a life estate in the property is vested in the surviving spouse, and the remainder vests in the children of the deceased. If the deceased has no children, then the surviving spouse inherits 1/2 of the separate property, and the other half goes to the deceased's parents. If no parents, then to his or her siblings or nieces and nephews. If the real property is not separate property and therefore is community property, if the deceased died before the law changed on September 1, 1993, if there were no children of the deceased, then the spouse inherited all the property. If the deceased has children, the children inherit all of the deceased's interest in the property. If the deceased died after the law changed on September 1, 1993, then, if there were no children, the surviving spouse inherits all the property. But if the deceased had children, then, if all the children of the deceased are also children of the surviving spouse inherits the property. If not all of the children of the deceased are also children of the surviving spouse, then all the children inherit the interest of the deceased. Title vests immediately upon the death of an individual, but how do we establish ownership under who are the heirs under law? The instrument used to provide ownership is called an affidavit of heirship. It requires two disinterested persons to witness and affirm the sworn statements as to who are the heirs of the deceased. Disinterested means the two witnesses must have knowledge of the decedent's family situation, but have no interest in the real property. The affidavit of heirship then will be filed of record in the county in which the property was located. This is the document to provide to the property tax office to get records changed. And this is the document that the title companies will use to establish who must sign any and all conveyancing documents. If the deceased dies with a will, probating the will can change vesting. The deceased, through his or her will, can convey the property to whomever they please. A will can be probated within 4 years of the death of the decedent. Use of an affidavit of heirship to establish ownership is not effective if a will is going to be probated. I hope this video podcast gives you some valuable knowledge as to passage of title upon the death of an owner. Allegiance Title is a fast-growing, independent title company wishing to become your trusted resource for results. Thank you.